For whatever reason, it seems like a lot of the cases that I get into are set in Florida. Maybe it just has something to do with the amount of population there. It's like the true crime nirvana for whatever reason, where everything really weird happens, really interesting happens. And the last case that I spent a lot of time looking into was the Dan Markel case, the murder of the Florida State law professor in 2014. And that case is really interesting because it still has a lot of activity going on 11 years later. The family matriarch of the Adelsons, who are the uh, alleged perpetrators in the case, that Donna's son, Charlie, has been convicted for the murder plot, but Donna herself is in jail right now awaiting trial. And I almost went to trial when it was previously scheduled, whenever that was, this summer, a few months ago. And I'm really glad that I didn't book a trip because the trial got moved by some really weird shenanigans. But yeah, I almost went to Florida just to sort of see what it's all about. I've never actually been there for whatever reason. It's one of the few regions of the country I've never spent any time in. But I thought better of it because I am from Alaska, and I looked at the weather forecast, and that was pretty much the deciding factor. It was like 95 degrees down there. But yeah, I've been really getting into the Madeline Soto case. It's a really interesting case, and I did a live stream with Grish, another creator who's got fantastic videos on the Soto case, a week or so ago, and it made me do a little bit more homework, cover the bases. And one of the first things that I really wanted to find out about involved the immunity laws in Florida. It's a really confounding situation, and it kind of reminds me of in the Markel case. There's a lot of speculation about Wendy Adelson, the Markel's ex-wife, and people are constantly going through their theories about why Wendy hasn't been charged yet, because she hasn't been charged, and she's testified in all three trials so far. And in Florida, there are unique immunity laws, and so both Jennifer Soto, the mother of Madeline, and Wendy Adelson have what's known as use and derivative use immunity. And we'll get more into what these terms mean, but it's a unique wrinkle in the Florida law, and there's some other unique parts of it, the timing of when those things can apply, that made me really sort of need to know that part first before I really started digging into other avenues, because it's, the question of what Jennifer's status is. Her partner or ex-partner, Stephen Stearns, is currently in jail awaiting trial on murder and CSAM charges, but she's out. And so just like Wendy Adelson, there's endless speculation about what's going on with Jennifer. She's going to be charged, what her deal is. And yeah, it just features the immunity laws in Florida in a context that's even more unique and more specific to Florida than the Adelson case, because in the Adelson case, the immunity didn't attach until trial when Wendy testified, but the timing issues are really well demonstrated in the Soto case, and so that's why I thought that this would be a good subject for a video on just sort of going over what I learned. The other thing I want to mention at the outset here is that in the description, I'm linking a Reddit thread where I sort of wrote up some of this material and linked to a bunch of further resources. So there'll be other things that I'll mention in this thing that are resources that I used for the video. And if you're interested, check out the Reddit thread, because it's got a lot of great links for stuff that I relied on in making this video. Florida in general is I don't know if there's just a number of things that have come up when I've been looking into criminal cases there that are sort of unique or curveballs. And I think I have a little bit of context on this, because as a research paralegal, I have done a bunch of projects where attorneys that I was working with wanted me to look into what a specific law is in all 50 states. And what are maybe one or two points about that law, what are the what's different about each one. And so you do that 4 or 5 times, and you have a decent flavor for the texture of how laws are and how the statutes are put together. It's every state has little wrinkles, and Florida definitely has some, but Florida is kind of a state of extremes, similar to Alaska in a way, although opposite sides of the country. But The other thing that, like, besides the immunity laws that like sticks out straight away is like their open records laws are like super open. So they're very well known for that, and that also has a huge impact on Florida, following Florida true crime cases, and that's probably answers like the point I made in the beginning where I was talking about, like, I don't know why it is like I always look into these Florida cases. Well, it's because they have these crazy open record laws, and so you get to see all of the material in cases, much sooner and much more often than you would in other states. So that's probably one good reason why Florida sticks out to me as having a lot of really compelling, interesting cases based there. The immunity laws in Florida allow Florida's law enforcement to compel the testimony of somebody involved in an investigation before trial, even, which I don't know if I should have researched this, but I'm not sure if any other state does that. Like, they have something called like investigative subpoenas where, they can pull you into essentially like something like a proffer session or a question and answer session where they hand you a subpoena and you exchange, your right to not incriminate yourself for what's known as use and derivative use immunity, which again we'll get more into the definitions of what exactly those are here in a moment. But this can also create like a lot of complications because, like if derivative use and use immunity, like if any of those type of things like happen at the trial stage, well, at the trial stage, like all the investigation has been done for the most part. Like the case is much more like set into cement, what the facts are. But in the middle of a case, it kind of introduces like another layer of uncertainty into cases that, to me, like as I was researching this, and another I think reason why I wanted to look into it is because it was like churning over in my mind so much because there are so many things that like about the nature of the timing of that these investigative subpoenas that made me just like think that there must be like a bunch of really bizarre case law, and I could just sense that there would be like a lot of weird edge cases where this would create unintended consequences down the line. And of course there was definitely some of that when I got into looking into what's out there in terms of law review articles and case law. And there's some of this and a lot of speculation about it in the Markel case. I mean, it hasn't actually been litigated yet to my knowledge, but I think one of the reasons why the Markel case is such a quagmire and why it's been going on for 11 years with more prosecutions in the offing and lots of speculation about about Wendy in particular still not being charged, is that she has this use and derivative use immunity. And so that's always sort of part of something that you see in Reddit posts. And, I think just like a week or so ago, Law and Crime put out a video, and there's been rumors that Wendy is going to be charged imminently. And I've been thinking about that, like in terms of like, strategically, would you want to charge Wendy before trial or after trial? Because then it presents all sorts of other questions. Like if you charge her before trial, I think that there has to be litigation about whether or not her and her mother's case would be severed. So it presents other legal issues and hurdles that you have to jump through before you get to trial. So to get back to subpoenas, one of the main things to remember about use and derivative use immunity in Florida cases is that these things are activated once you are served a subpoena in a case. And that's when they become relevant in a criminal case, is when subpoenas are served. And as I mentioned, Florida has unique practices about issuing subpoenas. Like in my state, I think the only time I've ever seen subpoenas issued is in the context of trial. Although there may be some other very minor uses for them, maybe for like the other type of subpoena where you're asking somebody to produce something. But I mean, as far as I've ever used them, it's always been in the context of a trial. But like I said, investigative subpoenas can be issued at any point during an investigation. And both of these types of subpoenas give a witness use and derivative use immunity in exchange for their Fifth Amendment right to not incriminate oneself. And the other thing that I took away from reading some law review stuff and just general literature on use and derivative use immunity is that it doesn't appear that they're retroactive, although I'm sure this might be a point on which somebody could litigate. But so, like, if a witness had previously spoken to law enforcement in a case on a voluntary basis and had later been served an investigative subpoena, then my understanding is that those earlier statements wouldn't be covered by use and derivative use immunity. This is especially relevant in the Soto case because Jennifer Soto spoke to police on, like, I want to say like 5 or 6 different occasions, maybe more, from the end of February till April 18th, 2024, when she was served an investigative subpoena. So it creates like another layer in some of these cases where you have like different groupings of statements that are covered by, in different types of, different levels of immunity or just different classes of statements and what they are covered by. So just to sort of, I'm just going to like really briefly mention like the timeline here to kind of put things into context for folks that may not be like super familiar with the Soto case. So Jennifer Soto reported that her daughter Madeline was missing on February 26th, 2024, and police issued that investigative subpoena for Jennifer on April 18th. So not quite 2 months lag there where, Jennifer was speaking to police voluntarily and on a fairly regular basis about a number of different subjects. But Jennifer's boyfriend or partner, sort of couched in different ways, even in Jennifer's recollection, Stephen Stearns was arrested on February 29th after police took his phone during their initial investigation and found CSAM on it. So he was snatched up pretty quickly. I think he, it's not exactly criminal masterminds here that we're talking about, and he sort of reads to me as like a super pathetic guy, and that's one of the things that really comes across in my initial stage of research, is just that these are sort of people living on the margins. Although I think Stearns has additional layers of interest because it seems like his family has at least some level of wealth, and so he comes off as sort of like a spoiled kid to me in some ways. But and also like one other date I want to mention here is that on March 1st, the body of Madeline was discovered in a wooded area, and that's a really sort of interesting aspect of the case too. I just recently listened to the police interview with the witness whose tip led police to finding the body, and it's just one of those things in a case that shows you how much sort of randomness is involved in investigations like this, because this Good Samaritan had called police and told them that he saw Stephen Stearns like looking weird, changing his tire on the side of the road, and later saw like a news bulletin where the police were asking for tips about Stearns and to try to find out where he may have deposited the body, because it was still sort of an open question about what exactly had happened with Madeline. And this Good Samaritan fellow calls police and gives them a pretty good tip, but for whatever reason, the person he talks to at the police is like, that's not very specific. Thanks, but no thanks. Essentially, like, just kind of blows him off. Which I mean, that type of lead to me is at least worthy of taking a note on, because it wouldn't really take that much to sort of follow up on it. But anyway, the guy goes above and beyond. I don't know how many people would do this. Like, what are the chances that the guy they blow off actually is like, all right, well, I'll go back and do a little, detective work and, find out more specific information. And he goes and, takes photos of the area where he said he saw Stearns and, leads them right to the specific spot and gives them some more information. And anyway, that's ultimately the tip that led them to the body, and just sort of his description of Stearns's demeanor, to me, all added up. And also like the way, the method that it seemed like the guy was like a real big car guy, and the way that Stearns was behaving around his car gave him the impression that he may not have legitimately had a wreck, and also where he was parked. So there's just like these little series of really good nuggets of information. This guy was obviously like a very smart and observant guy, and especially with regard to issues like involving mechanics of cars. And so that, to me, that's like the kind of guy that you want to take the phone call from and listen to if you're the police, because he's got some real reasons for making the call, and for sort of coming to the conclusion that maybe this would be a good spot to at least take a flyer on if you're doing searches. And the other sort of thing that's worth mentioning here is, generally the reason why people think that Jennifer Soto has some level of culpability in her daughter's death is that she was living in close quarters with Stearns and her daughter for years, obviously, and police say they recovered 4 years of CSAM from Stearns's phone. So, Jennifer continues to deny any knowledge. She hasn't been charged with anything yet. That's important to point out. And, if she was charged with something, she'd be presumed innocent. But it's one of those sort of things scenarios that sort of beggars belief. And so I think, that and other circumstances are the obvious reasons why people are so interested in this and so fixated on it in terms of an issue that they want to look more into before trial, which I think Stearns is scheduled for trial in September, but I think he's got a couple charges. So anyway, I might not be accurate on that because I don't have it here in my notes. But so the set of facts involving Soto's multiple interviews and the timing of the subpoena and the unavoidable question of whether she's going to face charges led to me encountering like a lot of speculation online, like trolling through Reddit and YouTube and other places. And people talking about if Jennifer's going to testify against Stearns, cut a deal with prosecutors. If she'd already cut a deal, I'd see that speculation a number of times, because people hear immunity and think that she must have already cut a deal. And that's all understandable because Florida's got, these unusual laws. But anyway, some of this stuff was like, I don't know, just sort of throwing me off. And I just kind of felt like I wanted to resolve this issue for myself before spending a lot more time digging into things, because it's sort of colors the way that you see the posture of the case for sure. So to put it all together here, before we get more into like the definitions and nuts and bolts and this stuff, Florida grants witnesses who are issued a subpoena use and derivative use immunities. Florida's district attorneys or prosecutors are called state attorneys. That's how they're referred to there. And they're the ones that can issue subpoenas at any point in the case. And again, if a subpoena isn't issued before trial, it's referred to as investigative subpoena. That's how it's referred to in the statute, which is in my Reddit post if you want to look at the statute on investigative subpoenas or the statute on use and derivative use immunity in Florida. So if you listen to the Grizzly True Crime, which I love those case file compilations for one for Jennifer Soto with like 8 or 9 hours of interviews, and then one for Stefan. Those are super convenient and great, and she did a great job putting those together. But if you listen to Jennifer's interview where she spoke to police on April 18th, 2024, you'll notice that she's with her lawyer, and they, at the beginning of the interview, the detective, or I think it might actually be a state attorney that's talking at the beginning of the interview, goes over the whole use and derivative use immunity that Jennifer received because of the investigative subpoena. So all that's sort of mentioned in terms of specific detail in terms of Jennifer's case at the beginning of that interview. I think it starts at around 3 minutes and 30 seconds in to that specific chunk of audio. And another area that's really tricky is there's like at least 3 different types of immunity that come up in criminal cases all the time. So I'll just go over like the 3 here really quick, so that we have our terms locked in. So use immunity means that the prosecutor can't use any of the evidence that you provide to subsequently prosecute you. This means like evidence that you give them like in a proffer session, evidence that you testify to at trial, or even physical evidence, like if you hand them an implement that was used in a crime, like a gun or something like that. they can't use that gun as evidence if you had use immunity. Derivative use immunity means that if the prosecutor decides later on to prosecute you in relation to something that you discussed while you had use immunity, they have to prove in a pretrial hearing that the evidence they are going to use to prosecute you was not derived from what you told them, that they got to that evidence independently, hence derivative use. There's also another stronger kind of immunity, which is immunity that you hear about a lot more often, which is transactional or blanket immunity, which is like when you cut a deal to turn state's evidence or become like a cooperating witness in a case, and the state either just gives you total immunity from being prosecuted for some set of crimes or a crime, or otherwise gives you some sort of deal that affects whether or not you can be prosecuted in the future for a crime. So, and even in like the case law, like this is so confused. We'll get more, like a little bit more into like the history of like why all this stuff is the way that it is. But like until pretty recently, like states didn't even agree on what these different types of immunity were, like which one was the one that should be the one to give to witnesses in situations like this. So the whole thing is a little bit muddled, and so I don't blame anybody for being confused by it. And I think that's, again, one of the reasons why I wanted to get to some level of understanding on this before I really felt like I could continue digging into the case, because it was just such a big question mark laying out there, and I kind of hate that when there's just like this sort of elephant in the room like this. So hopefully this helps other folks, but I know that it sort of gave me a level of understanding where now I feel I at least have some sort of basis for understanding where the case is at the moment. This whole confusing system of immunity is in place because the Fifth Amendment of the U.S. Constitution guarantees that somebody can't be forced to incriminate themselves. You can't force a witness to testify in a case where they have criminal liability. And this obviously created a lot of problems for the government in trying to prosecute stuff over the years. And there's been various different solutions and laws passed on this in different jurisdictions going back to like the 1850s at least. And it was historically most often comes up like in case law or in things that you read about the history of use in all different types of immunity laws, in cases where you kind of need somebody on the inside to be able to prosecute them. Stuff like antitrust cases involving corporations or organized crime, gambling, that kind of stuff. The first immunity statute in the U.S. came about in 1857 because a really random situation where a New York Times reporter said he'd been approached by members of Congress about a vote selling scheme. And, Congress obviously wanted to investigate, and they called this reporter before a House committee. And the reporter promptly invoked his Fifth Amendment rights, as he should have done, against self-incrimination. So in reaction to this situation, Congress passed an immunity act that gave anybody testifying before a congressional committee immunity from being prosecuted about anything they testified about. Sounds like a good solution, I guess. But this right here, this first immunity law, is a great example of how tricky this balancing can be and why these laws have had to be reworked so many times, because the broad construction and language of that first law led to this practice known as immunity baths, where people would be called to testify before a congressional committee, and they would just start testifying about every crime that they could possibly think of that they might have done in the past, so that they would be immunized against them, because the law didn't specify that your testimony had to be relevant to what you're called to testify to the committee about. So it's just this really weird wrinkle, and it's something that's maybe ripe for like future reading or something, because it's just like such a funny sounding situation. It almost sounds like something in like a I don't know, like a time travel Seinfeld episode or Curb Your Enthusiasm or something. But anyway, so the courts tried to find a way to balance the rights of the individuals and the collective rights of the government to enforce laws over the years, and it didn't progress very much from the 1850s until like the early 20th century, even really later than that. It's very slow and muddled progression when you read over law review articles, like looking at the history of it in different states or federally is the main place it developed over that time period. And there is no, like I said, no real agreement about which version of immunity was equal to the Fifth Amendment right, because that's like one of the main issues here is if you're going to give up your Fifth Amendment rights, you need to get like immunity that's at least equal to it. And because the right that you're giving up to like not say anything at all, and like the right to be immunized on some level from things that you do talk about are sort of so different, it's hard to like conceptualize of something that would be at least, you know, what one would equal another, because they're not exactly equivalent things in you know, because like, the way that I sort of think about it is like if you don't testify at all and you invoke your Fifth Amendment rights, it sort of forecloses a lot of possibilities for the government to prosecute you. But when you do testify and you're granted some sort of immunity thing, you know, there's just all sorts of emergent situations that come up that you couldn't anticipate. It's sort of why you're told not to talk to police at all. You know, it's the same sort of principle. And jurisdictions, you know, in different states and federally didn't agree on what, you know, some for like a good number of jurisdictions, they said that the only type of immunity that would be sufficient to equal your Fifth Amendment rights was, you know, what we talked about earlier, transactional or blanket immunity, just to make you totally immune from prosecution on that. And I think in some ways that's a strong argument. But other jurisdictions would grant you just use immunity or use and derivative use. And the other thing too that was like really sort of had to be just like a mess sorting out was it wasn't clear in all the different jurisdictions if this would apply to all jurisdictions. So like if you got immunity in a state case, does that mean that you can be still prosecuted federally or vice versa? Because that sort of really changes the the context of the deal and how valuable that immunity is if you can still get prosecuted, you know, in a federal case if, you know, you give up a bunch of stuff in an immunity deal in a state case. So in an attempt to clear this all up, in the early 70s, the U.S. Supreme Court handed down a decision in a case that's known as Castigar that implemented the current standard that we have of use and derivative use immunity equaling Fifth Amendment rights. You know, that's the exchange that you make when you get a subpoena. And it decided that these protections are equal to the protections you forfeit from the Fifth Amendment right. And it also addressed the jurisdictional confusion by concluding that the immunity offered in one jurisdiction applied to all other jurisdictions. So in other words, you can't be, you know, just sort of guarantee that you wouldn't be prosecuted federally if you testified in state court. There's still all sorts of weird issues about this. There's lots of interesting law review articles, and there's one that I linked about like what happens if you testify like in a civil case about something, and if that can be used even if you had a prior immunity deal. Like if you testify on the same subject in like let's say you get an immunity deal for like a criminal case, and then later on down the line you're pulled into like having to testify in a civil case about it. Can then that be used even if you had an immunity deal later on, because the government could, like in a derivative use or what's known as a Castigar hearing, named after this case we were just talking about, they could then say like, well, I didn't get the information from their testimony in the criminal case, I got it, you know, from the civil case. So that would probably fulfill the requirement that the evidence be found like independently of your testimony. So there's still all sorts of uncertainties and weirdness about this. And there's been a number of different challenges and changes to the immunity laws since the 70s, when this new Castigar opinion was handed down and this new version of use and derivative use immunity started federally. And then since then, like basically all states, I think that there might be like one or two states that don't have specific statutes on this, but it's still otherwise applies there. The other thing that was like sort of really interesting in reading about the history of this is that shortly after the Castigar decision, in the Watergate trial, and then also later in the Iran-Contra trials, there were witnesses who were compelled to testify and given use and derivative use immunity in exchange for their Fifth Amendment right not to incriminate themselves. And they later ended up being prosecuted and convicted. So that there's a lot of controversy about that, and like a few other cases that made some people question, and lots of legal challenges sprout up about whether or not this use and derivative use immunity are constitutional. And I think, basically, like I said, their complaint was that if they had just invoked their Fifth Amendment rights, they likely would not have been prosecuted. So it's hard to say that they're equal in those circumstances. But I mean, I think if your analysis is more broad and looking at the more macro perspective, I think in the vast majority of cases it probably is. Anyway, the Florida statute on use and derivative use immunity, which is 914.04, and again, it's linked in the Reddit thread in the description, lays out a lot about what I said about how the subpoena triggers immunity and the specifics of that. But it also talks about like the one major exception to this immunity that you get, which is that if you perjure yourself while under immunity, the immunity goes away, which is just like yet another crazy wrinkle in this weird scheme. And it's something that, again, has like a lot of weird edge cases and questions that come up. And a lot of these questions about like what happens when you perjure yourself are delineated in some of the law review articles that I read and that are linked in the Reddit thread, including stuff like, for example, like if you perjure yourself in a case and your immunity goes away, there's like a question at law about like whether or not it's just the perjured statements that can be used against you, or whether or not like even all of the truthful stuff that you said can be used against you. So there's just a lot of like unresolved questions that aren't addressed in the statute itself, or in like the Castigar opinion. So that's, I think, one of the reasons why this issue continues to be litigated, and continues to be confusing. The other Florida statute that I mentioned briefly before that's relevant here is 27.04, which is the statute on investigative subpoenas, which like gives the state attorneys or prosecutors the ability to issue subpoenas at any point in a case. And I excerpted the relevant portions of these statutes in that Reddit thread, but that one's interesting to read because it goes over how the state attorneys can issue these at any point that's convenient to them. And it's funny because you can tell the statute was like written a while ago, because it talks about how like at any point that's convenient to the state attorneys as they're doing their rounds. So I think this sort of anticipated, I can't remember exact language it uses, but it sort of anticipated like, I don't know, some like 19th century version of law or something like that. But yeah, they're interesting to just look at and see what it says within the four corners of the actual statute. So after digging into the particulars here, I think I answered like a lot of the main questions I had about where Jennifer Soto stands. Like I had been uncertain about like why she'd been given immunity, because I wasn't really aware of the scheme of investigative subpoenas in Florida. That I think was like what was causing a lot of the confusion for me, is I didn't realize that there's this limited form of immunity that was given out regularly in cases where state attorneys would want to pull people in for compelled questioning. And like I said, I'd seen a number of people online talking about that immunity and whether it meant that there was a cooperation deal. And I just think that this is speculation arises because of how random Florida's immunity laws are. But now I'm pretty sure that Jennifer was compelled to talk to police via investigative subpoena simply because she'd lawyered up. And her lawyer likely advised her, whatever the analysis was, based on the lawyer's thinking, that she shouldn't continue to volunteer to speak with law enforcement without being compelled to do so. I think that sort of makes sense. I mean, one of the things about Jennifer, listening to Jennifer's testimony or prior statements to police, the interviews before she got immunity, is that she was like remarkably evasive for large swaths of those interviews. So, but like it still, you don't want to just like offer up voluntary testimony, and over and over again, especially when you have some exposure. So in that sense, it makes sense for the lawyer to advise her not to continue to make voluntary statements. And the only question I have in my mind is like, yeah, I guess it doesn't really make sense. Like, because the other thing too that must have been going on in the calculus for the state attorneys in issuing that investigative subpoena, and that happens in all these cases, is that, Jennifer will get that same use and derivative use immunity if she testifies at trial for her statements there, because she's issued a subpoena for trial, as she would be for that April 18th hearing. So yeah, it's sort of interesting, because like one of the other things I've been thinking about is if you'd want to tailor your questions at all as a law enforcement officer or as a state's attorney to somehow sort of stay clear or deal with the use and derivative use immunity. But I don't think that must be that big a concern, especially like in a case like Soto, where she's given so many other prior statements, and they probably have 6 ways from Sunday to get to any other piece of evidence independently of Jennifer Soto's statements. So, but yeah, those are the sort of things I'm still pondering on, and we'll probably likely do some further reading on, because there's all sorts of interesting aspects to like how this affects the police's investigation and whether or not there's specific strategy they use in a investigative subpoena interview with a witness versus a voluntary one. That'd be an interesting subject to see if there's anything on that, like any good stuff that's written up about that. Like probably would be like in a manual for law enforcement in Florida or something like that. But yeah, to put a bow on this, immunity issues are tricky in any jurisdiction, but Florida and their investigative subpoena statute, which can induce somebody to talk to law enforcement at any point in a case, makes the immunity issues even trickier by putting them into the flow of like an already uncertain and developing situation in an investigation. And by and large, the investigations where state attorneys are going to go through the time to issue these investigative subpoenas are going to be the ones that are more complex. So it just adds like another layer of things to think about in these cases. And the Soto case to me is almost as compelling for like what we don't know or what's left unsaid about the case as what is already known. I recently was listening to a YouTube video where another YouTube creator like read all of Jennifer's old LiveJournal blogs that are still online, and it was just striking to me on the one hand how ordinary Jennifer Soto seemed in the early internet format, but also how sort of featureless and ineffable her life was. It's like hard to really get much of a texture for her because she just seemed so, I don't know, so inert. Like she just didn't really have much of I guess maybe just a sampling of random LiveJournal blogs isn't super fair to judge somebody on, or their early self especially, but she just seemed like she didn't really have much of an inner core sense of herself. There's like a smattering of things that I learned about Jennifer Soto when I reflected on like, what did I actually learn about Jennifer Soto from her LiveJournal blogs? And I think a lot of it too is like stuff I probably could have guessed at, but like one of the main themes was how indecisive she was. She said she's like something like, I'm the most indecisive person that I know, which is like not a great quality. She had a fraught relationship with her mother, which, what young adult doesn't, I guess. And she also at one point wanted to join the military, which I don't think ended up happening, and I'm sure it would have been a complete disaster if she did. Although who knows, maybe it would have shaped her up. But one of the things I'm always sort of conscientious about and like thinking about as I get interested in the case is like, what attracts people to digging into specific cases. And it's just something that inevitably occurs to me as I'm getting into the weeds of a case myself and thinking about the community that surrounds different cases. And there are many aspects of the Soto case that I and others are probably responding to and wanting to understand. But the parts of the case that I've been fixated on recently involve Jennifer Soto. And I think that's because she's such a cipher. She's so impossible to know at this stage. And maybe I'll find out more as I continue reading and listening and watching to materials on the case. But it's just like I want to sort of know who Jennifer Soto is and if there's something specific to her that made her so complicit and uncaring, apparently, in the abuse and death of her only child. Again, she hasn't been charged with anything. There's just something about her visage, the way that she looks on camera, especially in those early interviews. And it just makes me wonder how this featureless live journal writer girl become the woman that I see in the footage and photos in this case with those crazy dinner plate eyeglasses, which weirdly seem to sort of magnify her already wide-eyed expression. Normally, there's like a cliche about like seeing something in the eyes of a person, but in Jennifer Soto's eyes, I only sense a void, which is, it's just one of those things that pulls you into a case and wants you to know more, and makes you want to know more. So hopefully I will have some other angles to make videos in this case that I think might be something that'll help other people understand it a little bit deeper. Thanks for watching the video. I'll see you on the next one.